Well, good morning. I'd like you to imagine this, and I'm sure we've all experienced this situation. You're talking to an early stage med tech company, or maybe you're the early stage med tech company. You know, you're listening to that new person that you just met from this early stage med tech company, and they're telling you about this great technology that they developed and all the time and all the money that they're putting into the development. But let me ask you this next question. When you think back on those conversations, again, whether you're the early stage company or the listener listening to that pitch, how many times do you recall the conversation going on to the topic of, and we've got actually the legal freedom to make and sell our technology? Now, when I think about it, it's pretty few. And that's the subject that I wanted to address today. So, why is this topic of concern to you, whether you're the early stage company, whether you're the investor in that early stage company? Well, some of the things is that medtech owners often operate under mistaken beliefs about their rights under patent law. Maybe in some ways more importantly, patent owners of those medtech companies have some mistaken beliefs about their rights under patent law. Perhaps even more importantly, if you're the medtech company, if you're the investor, if that company doesn't have that legal right to make and sell their technology, maybe they really don't have a business to be investing in. Maybe they really don't have a business to really operate and shouldn't really be going down that path that they're thinking about going down. The other is that this medtech company might be spending a lot of time and money over a few years, or actually a number of years, and then find themselves involved in a patent infringement lawsuit and perhaps end up paying out millions of dollars for patent infringement. So let's kind of go back to these possible areas of mistaken belief. So one thing that the patent law does is that when I get a patent, it just gives me the right to exclude somebody else from making, using my invention. It gives me the right to exclude somebody else. What it doesn't do, it doesn't give me the right to make and use that invention. Okay, so conceptually, is that making sense to people? Well, that's good, because for the most part, people have difficulty in understanding that. And so let me kind of give you an example. Everyone's sitting here, I think, in a four-legged chair. So my competitor has a patent that covers a four-legged chair. You know, I'm the new startup. I come up with the idea of putting 5 legs on it because it's going to be a more stable chair. And because of that great idea, I actually get a patent on it. So I've got a patent for a 5-legged chair. My competitor's got a patent for a 4-legged chair. And when I go out and start selling that 5-legged chair, I'm actually infringing my competitor's 4-legged chair. Because with my 5 legs, I'm actually selling something that has 4 legs on it. I might have that additional 5th leg, but I am still selling a 4-legged chair. So that's why it's important to understand that difference, if you will, of just because I've got a patent doesn't mean I'm not infringing somebody else. All right? Just because I've got a patent doesn't mean I'm not infringing somebody else. Okay, let's go back again. If you can't make or sell your patented device, you probably have no business in being in the business that you're in. Right? If you're not going to be able to make any money, there's no reason for you to be in that business. Now, maybe you need to change your device, but with that device that you've got, if you don't have that right to make it and sell it, you better get something else. Okay, so how do you get around this problem, or how do you try to address this problem? Well, there's these things called freedom to operate opinions. And that's some opinion from some patent attorney that's going to tell you that your patented or even unpatented device is, quote, safe from infringement. Okay? It doesn't infringe somebody else's patent. So, one of the challenges of getting this freedom to operate opinion is that you might be making your product in one country. You might be selling your product in multiple countries. And the way the patent laws operate is that the patent laws are country by country. That means that even though you may not be infringing someone's patent in the United States, but you're selling your device in Asia, or you're selling your device in Europe, you could be infringing somebody's patent in Europe, or you could be infringing somebody's patent in Japan. So, these types of freedom to operate opinions, if they're going to be useful, they probably need to cover those countries where you're going to be doing some significant amount of business. Okay, the scope of these opinions can vary. They can be very narrow, and they can be very broad. Oftentimes what happens with a medtech startup is that they'll identify some competitor of theirs, and they'll know about some patent or patents that they hold. And they want to make sure, or maybe they should make sure, that they've got the ability to sell that product without infringing that one competitor's patent. On the other end of the spectrum, the opinion can be pretty broad. And broad in the sense that the search for these relevant patents can cover literally hundreds of patents, not just in the United States, but abroad as well. So sometimes what companies will do is that they'll use their scientists or engineers to kind of, reduce that attorney fee cost, have their engineers or scientists try to make some preliminary filtering of what might be, a patent or patents of interest, and then get the attorney involved in it. Now, I saw some shaking of a head right there from someone who I just met this morning, and I know he's a patent attorney, and he's saying, no way. Why is that?
It could lead to issues in terms of if you have an infringement against you and you try to say that you're not willfully infringing, you can allege that you are. And if that prior art isn't necessarily disclosed to the patent office, you could be paying trouble damages.
Okay. That's a good point, but probably for most clients, they kind of tend to be pretty cost sensitive. And in my experience, what I find is that cost takes precedence over those, I guess, legal concerns, if you will. Again, scope of the opinion, they can be very narrow, very broad. Some patent opinions for these freedom to operate situations will only address infringement. Okay, they won't address the validity of a patent. So why is that important? If you've got an invalid patent, you can't infringe it. So sometimes a medtech company will say, okay, we need to know if this patent is invalid. And oftentimes that question is being asked because there's a big infringement problem, meaning that it seems somewhat clear that they're infringing, and so maybe a way to avoid that problem is to determine that the patent is invalid. Okay? So we talked about having engineers or scientists involved. The search can be done by patent attorneys. The search can be done by in-house personnel. The probably biggest challenge, if you will, with doing any of these types of searches is that if you just look in the United States, there's going to be millions of patents that could potentially be at issue or have to somehow be filtered. What I mean by that is this. So a patent can last for 20 years. Patents are being issued all the time. And the way most searches are conducted is that someone has to come up with some key words. And based upon those key words, an attorney or some in-house personnel will be able to locate patents that might be potentially relevant. But if you kind of just total up the number of patents that are in existence in the United States, even though they may or may not be within the possibility of infringement, you're going to have 1 million patents to look at. Then when you have to start to worry about, what's going on in Japan, what's going on in Europe, you're starting to compound that number. So it can start to become a very large problem. So you hire some patent attorney. That patent attorney gives you an opinion. The opinion isn't a guarantee. It's not a guarantee that that attorney found every possibly relevant patent that you might infringe. It's only that attorney's representation of what he or she believes a judge might eventually find if you end up in court in a patent infringement lawsuit. The costs, a few thousand to tens of thousands to over 100,000, depending upon how thorough you want to be. But probably the bigger cost is the business cost. Again, what do I mean by that? And that is that, you're all happy because you've got a patent or all these patents. You've been making these products, selling this product in the U.S. and in different countries, and you're starting to gain a lot of traction. You're starting to generate a lot of revenue, and your competitors are starting to see you on their radar. And they're thinking, well, this particular company is starting to take over some market share. They're starting to be a real competitor to us. So now we're going to assert our patents and sue that startup for patent infringement. You end up in court, you end up with a judgment against you. Maybe it's millions that you end up spending for that judgment, as opposed to the cost of that opinion. So, the takeaway is just because you've got a patent doesn't mean you don't infringe. Questions?
Michael, would you comment on the case where you have knowledge of a patent and you go ahead anyway?
Sure. So, and this was kind of alluded earlier. You know, one of the, I guess, downsides, if you will, is that when you do a search and you find these patents or patent that is problematic, and then you say, okay, well, we're just going to forget it. It's not that big of a problem. And you continue down the road of, selling your product. And then you get successful. Then you get sued for patent infringement. There is some possibility that you might be liable for increased patent damages because you knew about the patent and you went ahead and infringed it. And you went ahead and knowingly infringed it. So that's where you get into some possible problem. So you kind of have to weigh that against, do I want to just be blind to everything that's out there? It's a difficult call, but I guess for me personally, I always end up on what I would consider the more conservative side, and that is I'd rather know about something, figure out if I can do something about it, and then move forward. Anything else? Okay.
Yeah, you mentioned before how some companies use scientists or engineers to create a filter. Is it advisable to use, say, a patent agent who has some knowledge of the field and then to work in tandem with the patent attorney?
For me, I guess I don't really make that big of a distinction between patent agent and patent attorney. If that patent agent is being used, again, to kind of just filter things so it can get down to kind of something more manageable, I don't see a disadvantage in using that type of a person as opposed to a patent attorney. I think, in the end, if you're looking for that patent attorney to give you a written opinion, you probably need it to be from an attorney as opposed to an agent. The other thing is that, opinions don't have to be in writing. So again, if you're cost conscious and, worried about spending a lot of money, you can have that attorney just go through the analysis and tell you, here's a problem, here's no problem. Okay? Thank you.